Welcome. Good morning. Um, Welcome to Sunday Morning Coffee with Dr. Childress. Today, I want to be talking about holding the mental health professionals accountable for competence. Um, this is distressing for me. I don't like to get people in trouble, but there are obligations. They have obligations to you, and you have rights relative to professional competence. So let me just set the stage a little bit um, relative to what I'm going to be discussing. So I entered the field of court involved custody conflict about 10 years ago. And my practice or my life in psychology wasn't in this pathology. It was everywhere but here because clinical psychologists don't work in the family courts. It's too professionally dangerous. The phrase you will hear from the clinical psychologists is, I don't work with high conflict divorce. You want a forensic psychologist. So they'll refer you over to the forensic psychology people. And that's the source of a great deal of in fact, the entirety of the problems in the family courts is that about the 1980s, professional psychology made a risk management decision about how to handle the issues and the dangers of the pathology in the family courts. They decided to develop your own special psychologists called forensic psychologists, and all the clinical psychologists went away. And that keeps us safe as clinical psychologists, and hopefully the forensic people would take care of you. They didn't. They wound up exploiting you financially and not solving anything over here. The forensic psychology and the forensic custody evaluations are, in my opinion, a failed experiment in the family courts in service delivery to a vulnerable population. Clinical psychology needs to return, and the whole practice of forensic custody evaluations needs to end. We need accurate diagnosis and effective treatment, and the court needs to be told what that diagnosis is. The differential diagnosis for severe attachment pathology is possible child abuse, either by one parent or the other. Either the targeted parent is abusing the child, creating the child's attachment pathology towards that parent, or the allied parent is psychologically abusing the child by creating a shared persecutory delusion and false attachment pathology in the child. So it's going to go child abuse one direction or another. We just need to know which parent is creating the child's attachment pathology. Uh, and when I first entered this field a decade ago and started to look around at what was happening here, I'd worked with pretty much every other pathology out there: ADHD, oppositional defiant disorder, school-based problems, juvenile justice, depression, anxiety. I've even worked at three cases of selective mutism. You never see selective mutism. I've had three cases of that. Factitious disorder imposed on another. I've worked with that. Dissociative disorders, dissociative identity disorders, even geriatrics. I worked with every other possible pathology before I came to the family courts. This is like the last one on my list. I wanted to see what was going on over here. Everybody knows it's narcissistic and borderline personality disorders. So what's the problem? Why can't you guys fix it over here? So I came over here and looked around, discovered what the problem was, and was appalled by the absence of professional competence in the family courts, and by the active trauma and active child abuse over here. So I have duty to protect obligations as a clinical psychologist. So I stayed here, and I am fulfilling my duty to protect obligations as well as ethical obligations under standards 1.04 and 1.05 of the APA Ethics Code. When I become aware of ethical violations by another psychologist, I have to do something. Standard 1.04 says informal notification. So at this point, my reports, professional reports into the court and for my clients, satisfy that obligation for informal notification of my ethical concerns to the involved psychologist. But standard 1.05 says if that doesn't solve the problem, then additional steps are warranted. Uh, and so I'm taking additional steps. I attended 2017. I went to the national convention of the AFCC and told them what the pathology was. In 20, like 28, somewhere around 2008, 2009, maybe 2010, I recorded a whole set of videos from my Pasadena office that are up somewhere on YouTube where I described the pathology. I wrote essays about it, put them up on my blog describing the shared persecutory delusion. So I was describing it a decade ago. 2015, I wrote a book that described it in detail across 3 levels of analysis: family systems, personality disorder pathology, and attachment pathology, not only within each level of analysis, but I integrated all 3 levels. The attachment pathology creates the personality disorder pathology, which creates the family systems pathology. That's my book Foundations in 2015. Now, I have no obligation to educate these people. Under standard 2.03 for maintaining competence, it's their obligation to remain educated and to get educated. It's not my obligation to teach them, but I am documenting that I did inform them. I informed the AFCC at their national convention, and the slides are up uh, relative to a set of about four or five slides that are the key points where I pointed out, described the boundary of competence violations in forensic psychology. And then the rest of my slides were about describing what the pathology was. And then I brought Dorsey with me, and she introduced her and the high road to the forensic psychologist at the AFCC, because I also felt that was my ethical obligation. She has a solution. She has a workshop, solves it in 4 days. People should know about it. So I escorted her and introduced her to the professionals at the AFCC. That was pursuant to my ethical obligations under Standard 1.05 to take additional steps. I also generated a petition to the APA that was signed by roughly 20,000 parents. I hand delivered it to the offices of the APA, again, pursuant to my obligations under Standard 1.05 to take additional steps as warranted when I'm aware of ethical violations. And so that documents that both the AFCC and the APA at this point are in collusion with the unethical practice. They're not doing anything to stop it. And they are both aware of it. I've taken steps to make sure they're both aware of it. And they should be aware of it just on their own. That's their own obligations, but to be competent. But if they're not, I've made them aware that they're not competent. They're not competent in the assessment of delusional thought disorders, or in the family systems pathologies, or in attachment pathology. And so all of them are practicing beyond the boundaries of their competence. I've given them ample opportunity to adjust to the information, to the new information. I published my book in 2015. So they just simply are not doing anything to improve the competence within their field. And I have ethical obligations, duty to protect obligations to the parents and to their children. And so from my perspective as a clinical psychologist, my next steps in this situation is to educate the consumer mental health professionals regarding the nature of the pathology and their rights, uh, so that they are able to effectively advocate for their children, to get appropriate mental health services, to get an accurate diagnosis and effective treatment for their children and for themselves. This is a child abuse pathology, so we have protection obligations here. And the parent, the targeted chosen parent there is trying to protect their child from child abuse, and we have obligations. I have obligations as a psychologist relative to that, and they're trying to protect themselves from spousal abuse. This is psychological abuse of the targeted parent using the child as a weapon. And so, empowering the victim of spousal abuse to effectively advocate for themselves and for their child to protect themselves from the abuse is an obligation of me as a clinical psychologist, given the situation. No, normally I would refer you to your local mental health professionals for protection. Unfortunately, they are colluding with the child abuse. In many cases, the involved mental health professionals are the child abusers. If you believe a shared delusion, you become part of the shared delusion. You become part of the pathology. And when the pathology is child abuse, and when the pathology is spousal abuse, you then become part of the child abuse and spousal abuse if you believe the shared delusion. And so there's a great number of the mental health professionals in the family courts believe the shared delusion and thereby become part of it. And even if they don't believe it, even if they understand there's pathology involved, if they fail to diagnose it, they're failing in their duty to protect obligations. So they're still part of the pathology by failing to protect the child from child abuse. In the bystander role. And more specifically, that bystander role in clinical practice and trauma is called the betrayer role. It's the one who should protect and doesn't. And that's the current role being filled by the forensic psychologists. They are in the bystander role, specifically the betrayer role. They're the ones who should protect and aren't. So under that, I feel I have professional obligations relative to the victims of spousal abuse and child abuse to duty to protect obligations and ethical obligations to you. So, in that line, I view my obligations are to educate the consumer of mental health services regarding the nature of the pathology so that you can become informed consumers and effective advocates for yourself and your children, and to empower you to obtain professional competence and to your rights relative to the unethical and incompetent practice that surrounds you. Now, the appropriate resource or that I should refer you to for the redress of your grievances would be the licensing boards. If consumers of mental health services are dealing with potential incompetence in their providers and violations of ethical standards, and we'll talk about that in a little bit, then the appropriate venue for their grievance is a complaint to the licensing boards. Um, I do not want to create harassment of mental health professionals or seeking of grievances and revenge. That's not the motivation. At the same time, uh, the children and the courts deserve competence, basic levels of competence, and the minimum level is compliance with the APA ethics code. Uh, so that's non-negotiable. Ethical practice is obligatory for psychologists. It's not optional. So the APA ethics code for psychologists is mandatory. We'll talk about that in a second. So if there are violations to that and you're concerned, then the appropriate venue for your grievance is a complaint to the licensing board. In addition, their malpractice may be applicable given the negligence and dependent upon the situation. So again, this isn't about revenge or harassment. This is serious matter. When you file a complaint against somebody's license or malpractice, you're threatening their career, all their education, all their work. That's how they support their family. Their entire life is in danger. And so it's not something to be taken lightly. uh, and so with due consideration. So, with that in mind, let me talk a little bit about asserting or your rights and obtaining competence from the mental health professionals and holding them accountable. Uh, what I did when I got over here is I did sort of a workup of what your problem was. I have background training in community um, psychology and organizational development and systems change, those sorts of things from my master's degree. So I came in here and did a research and took a look at what the situation was over here. And it was clear that the failure, you have two failed systems, failed mental health system and a failed legal system. And the reason the legal system is failing is because fundamentally the forensic psychologists are failing the courts and failing the families. It's a failed experiment. And so we start by fixing the mental health system, and then we can use the mental health system to fix the legal system. The problem is we're not getting an accurate diagnosis and effective treatment plan out of the forensic people. They're not solving the pathology. They're not even identifying what it is. They're not applying knowledge. They're not competent. And that's what I recognized early on, is they are not competent. It took me about 20 minutes of my first encounter with this pathology to have it diagnosed as a shared delusional disorder, the narcissistic spectrum parent, and the cross-generational coalition emotional cutoff. 20 minutes of my first session. They're doing 40 years over here and have no clue as to what the pathology is. In 40 years, have you heard any forensic psychologists describe cross-generational coalitions for the court? No. How about shared persecutory delusions? No. Factitious disorder? No, they don't explain anything. For 40 years, they've been fighting about this concept of parental alienation. It doesn't exist. That's the worst model of a pathology ever developed by Gardner. No, that's awful. No, apply knowledge. Gardner skipped the step of diagnosis. He thought he was entitled to just to make up a new pathology. No, you're not entitled to do that. What you are responsibly obligated to do as a professional is to restrict yourself to the application of established knowledge. If he had done that, the pathology turns out to be a cross-generational coalition, emotional cutoff, and a shared persecutory delusion if you apply the knowledge to it. But he didn't, because he didn't know the knowledge. So he just, instead of learning the knowledge about attachment or anything, he just says, I can make up a new pathology. No, you can't. And because he was negligent in his professional obligations, Gardner, he threw the entire field into 40 years of conflict, unnecessary conflict. Forensic psychologists, though, are equally responsible, because they said, no, this parental alienation is not a good concept because it's not based in established knowledge. But then they didn't apply the established knowledge. They didn't take it the next step. So when I got over here, that's what I did. I applied the established knowledge. The moment I did that, the moment I define the pathology using the established scientific and professional knowledge of the discipline, I activate the APA ethics code around professional competence. There are now defined domains of knowledge that need to be acquired for professional competence over here. That's not true if you're using parental alienation. There's no competence standards for that. You can just assert, I'm an expert in parental alienation, and all of a sudden you're an expert. You don't have to be an expert in anything. You just assert, I'm an expert in parental, because there's no such thing as parental alienation. I'm just making it up. So that's no. We can't hold professionals accountable to something that doesn't exist. We can hold them accountable for attachment and attachment pathology in the attachment system. We can hold them accountable to family systems therapy. We can hold them accountable to shared delusional disorders in the DSM-5 and child psychological abuse. And we can hold them accountable for established knowledge. And that's what we're going to do. And it begins with standard 2.04, the bases for scientific and professional judgments. That's the entry point on holding mental health professionals accountable. It's going to be a triad of line of three ethical violations that are the core of the issue for them and holding them accountable. On entry, it begins with 2.04 bases for scientific and professional judgments, that they are required to apply the established scientific and professional knowledge of the discipline as a basis for their professional judgments. The established scientific and professional knowledge of the discipline is attachment, family systems, complex trauma, personality disorders, DSM 5 from the American Psychiatric Association, delusional thought disorders. And so those are the domains of knowledge that they need to have in order for professional competence. And those are the domains of knowledge that they need to apply. Now, in my consulting practice, I developed a checklist of applied knowledge, and I use that to document whether or not there's evidence in their report of their application of the established scientific and professional knowledge of the discipline. I look at 6 domains of competence and identify 5 constructs, 5 potentially relevant constructs in each domain that of professional practice or professional knowledge that could or should be applied surrounding family court custody conflict, as well as 2 practice domains, diagnosis and treatment planning. And it's just a simple checklist. There's anything there. And I use that to document whether or not there's any compliance with 2.04. And so far, there's none. I've never reviewed a forensic evaluation that has any applied knowledge. And because the court fights about everything's adversarial. When I come with an opinion that there's been a violation to this 2.04, everybody's going to fight about that. Well, no, he did applied knowledge from parental alienation, but there's no such thing. And so but by documenting it, I'm just establishing none of this information was there, and that's not something we can argue about. Show me where in the report any of these constructs were used, and it's up to the forensic person to justify why they didn't apply family systems constructs when they're assessing a family, or apply constructs about delusional thought disorders when the diagnosis is potentially a delusional thought disorder, or attachment constructs when you're assessing attachment pathology. That's for them to deal with on cross-examination. So that checklist is up on my consulting website in the attorney resource section. So you can just go there and I document, tell everybody this is what I'm looking for when I'm looking through something. You can use it too. You may not understand the constructs necessarily, but did they use any of those words anywhere? Do you see anything close to that anywhere used? The attorneys can use it. Dorsey, you can tag for it if you want. Now, I have the advantage because I'm a psychologist. I know what those constructs are, so I can read for whether or not any of them are even closely encountered. But I can guarantee you'll know if they've used the established knowledge. It'll be evident there. They'll be talking about the attachment system or regulatory objects or personality disorders, or they'll be talking about something. And so the entry point is 2.04, that there was no established scientific or professional knowledge applied as the basis for their professional judgment. The next ethical standard in the series is 2.01, boundaries of competence, because if they didn't apply any established knowledge, do they even know the established knowledge of professional psychology? So that's boundaries of competence 2.01, and that you would look at their vita on. And for most forensic psychology people, I call it a very thin vita. They've worked a lot in the family courts, but they haven't worked with anything else. And so they have no background in delusional thought disorders. I can pretty much guarantee you that, because that background only comes out of schizophrenia. You don't see it anywhere else except like the psychotic people. And that's where I got my training, is I worked for 12 years on a research project on schizophrenia. So I do have the knowledge of how to, assess and diagnose delusional thought disorders. I can guarantee you the forensic psychologists don't. And so they're practicing beyond the boundaries of their competence relative to the diagnostic assessment of delusional thought disorders. And 2.01 is the primary one on that. But then 2.01 C and D amplify that if they are practicing in a new domain, and delusional thought disorders would likely be considered a new domain for all of them, then they should seek consultation. If they are providing emergency services so that services aren't denied, and they have closely related experience, like in the family courts, then they can work with somebody that's 2.01D, yet they still should seek consultation. They still have to take steps to acquire the competence in the diagnostic assessment of delusional thought disorders or attachment pathology or personality disorder pathology, whatever the boundaries of competence are. Right now, the forensic psychology people are essentially plastic surgeons doing open heart surgery. Yes, you may be a doctor. Yes, you may be a surgeon, but you should not be doing open heart surgery. You're a plastic surgeon, you're a cosmetic surgeon. If you're going to do open heart surgery, then you need to get additional consultation and training. And if you're in the Antarctic and you're the only doctor available and have to do open heart surgery, then you need to get on the internet and get to a heart surgeon to get the competence to do open heart surgery. You're not allowed to be incompetent, because if you are, your patient's going to die. And this is child abuse in the family courts. So if you misdiagnose the pathology, you become part of the child abuse on this one. So this is really, really important that the mental health people get an accurate diagnosis 100% of the time. Because if we misdiagnose it, that's a bad thing. We're sending a child to child abuse, one way or the other. So the people who are against parental alienation, I agree with them. We need to protect children from child abuse and false allegations of parental alienation. We also need to protect them on the other side. My statement about that is dogs exist and cats exist. And the existence of dogs does not nullify the existence of cats, and vice versa. And yes, both have four legs, fur, and a tail, but we can tell them apart. There's a variety of ways to tell dogs apart from cats. And that's what we have to do 100% of the time. We have to identify authentic child abuse by the targeted parent, rejected parent, and we have to identify the shared delusion by the allied parent whenever it's present. Whatever the child abuse is, we need to accurately identify it 100% of the time. So the first ethics violation is to 2.04, bases for scientific and professional judgments. The reason they were in violation of that is because they don't even know the knowledge. It's a boundaries of competence issue, 2.01. Now, all the two ethics standards are competence. That's the category for competence. The other relevant competence standard is 2.03, maintaining competence. That it's not my job to educate them. It's not your job to educate them. It's their job to already know. Okay. So that's important to understand. When parents say, how do I, educate my mental health professional? How do I, I'm giving them booklets. I'm trying to tell them what the pathology. You shouldn't have to be doing that. Not, and nowhere else in healthcare does a patient have to educate the doctor about what the pathology is. That gives you an indication of how below standards of practice it is over in forensic psychology when the patient has to educate the doctor. And so, yes, you do, because this is important, and you do need an accurate diagnosis for your child, and you kind of do have to up the standards within professional psychology by educating your doctors about what it is. But fundamentally, they have an obligation to know. So that's 2.03 on there. But the main line is that you're arguing relative to their opinions is that they didn't apply the knowledge because they didn't know the knowledge. And as a result, there's a violation of 9.01A, which is bases for assessment. So the forensic psychologist conducted an assessment, their custody evaluation, or the reunification therapy, there's no such thing, conducted some sort of assessment of the family, came back with some sort of diagnosis. No, they didn't, but they should. But their 9.01 is the applicable ethics code standard for bases for assessment. And if they do not know the required knowledge for competence, and they did not apply the knowledge, the established scientific and professional knowledge of the discipline, 2.01, 2.04, then their opinions, as contained in their recommendations, reports, diagnostic and evaluative statements, including their forensic testimony, are not based in information and techniques sufficient to substantiate their findings, in violation of 9.01. And 9.01, right at the end, specifically cites back to 2.04, bases for scientific and professional judgments. So it's like a little circular ring, that because they did not apply the knowledge, their opinions are not based on the information and techniques sufficient to substantiate their findings. Information is standard 2.04, the established knowledge. Techniques in this case would be a mental status exam of thought and perception. That is the assessment for a delusional thought disorder. And it's a specialized expertise in conducting a mental status exam for thought and perception. The quote I draw from Martin up on the National Institute of Health website is that it requires considerable experience to conduct a mental status exam of thought and perception. And that's true. I have that considerable experience from 12 years of training out at UCLA. None of these forensic psychologists have that experience. None of them conduct a mental status exam of thought and perception. None of them discuss the possibility of a delusional thought disorder. None of them discuss the possibility of child psychological abuse or a possibility of a factitious disorder. So that they're not discussing a lot of things, but I can pretty much guarantee you there's no section about their assessment of delusional thought disorder, whether or not there's a persecutory delusion, and their conduct of a mental status exam of thought and perception. So that's the information and techniques that have put them in violation of standard 9.01. So that is your ethical line to move through, that we should not rely on their opinions because they're not based on information and techniques sufficient to substantiate their findings, because of a series of ethical violations. Now, I draw professionally, as I do my analysis, on the quote by Walters and Friedlander in the journal Family Court Review from 2016, where there's two sentences, and they're again up on my attorney resource section of my website, but they discuss how the pathology of a resist-refuse dynamic, and there's no such thing as that either. That's I wish they would stop making up new pathology, but that this family court pathology is often a persecutory delusion created by the pathological parent imposed on the child. And so those two sentences support that they know it's potentially a delusional thought disorder. So they should be assessing for that as part of the differential diagnosis. And the assessment is a mental status exam of thought and perception. So they should all be doing a mental status exam of thought and perception. But they're not, because they don't know how to do it. They're not discussing it. They're not doing a proper assessment for a possible delusional thought disorder. And if you Google the word negligence, it's failure to take proper care in doing something. And so that's why I keep using the word proper. They didn't do a proper assessment. They failed to take proper care in assessing the pathology. When you know it's a possible delusional thought disorder, you should know. Do you read the Family Court Review Journal, the flagship journal of the AFCC? Do you even even know that? I told you in 2017, I went to your, national convention and told you that it's a shared persecutory delusion. And you told in 2016 that wrote a book about it. You should be assessing for it, and you don't know how to assess for it. And so that's your information and techniques. And they're kind of dead in the water when the information uses standard 2.04 and refers back, especially if I've done the checklist to kind of document that they failed in 2.04. So the ethical violations, if you file an ethics board complaint, the ethics board does not care about the specifics of your case. They're like an appellate judge. The appellate judge is not going to retry the facts of the case. They're just going to look at, was the law properly followed and applied, and were all the procedures proper. They're not going to retry the facts of the case. So when you file an ethics board complaint, they're not going to want to know all the details and how they misdiagnosed the pathology and all those sorts of things. It's going to be, what are the ethical violations? It's 2.04, failed to apply the knowledge. 2.01, they failed to know the knowledge. That's from their vita. And it's delusional thought disorders, attachment pathology, personality pathology, child abuse, complex trauma, um, child development, just variety of areas you can go. The strongest are on the delusional thought disorders and attachment pathology, family systems as well. Those are your strongest arguments to make, that they failed to apply knowledge, they failed to know the knowledge on their vita. As a result, they're violation of 9.01 bases for assessment. And that sentence on 9.01, the fact that the APA identifies opinions contained in their recommendations, reports, diagnostic or evaluative statements. So they are using evaluative or diagnostic. They're saying, forensic people, this applies to you too. Diagnostic, including forensic testimony. So they even note forensic testimony. They're including the forensic people on 9.01. That has to be based on information and techniques sufficient to substantiate their findings. It's not. So that's the series. And as professionals, as parents, as you come together in a single voice with the same ethical violations around competence and assessment, you will be educating the licensing boards around the obligations of professional competence and ethical standards. The licensing boards are not likely to do anything because they're staffed by the forensic psychologists. And if they find that that person didn't apply knowledge, well, then they're equally as guilty of practice beyond the boundaries of their competence. So the licensing boards will likely cover up and just simply not investigate them, but make them do it over and over again. And put them in a difficult position. If parents just keep submitting based on these three same standards over and over, because truth is truth, and they are not competent in the attachment system or the assessment of delusional thought disorders. And that's the truth, and that's the problem. You're getting misdiagnosed, a shared delusion, they believe in it, and becoming part of the child abuse, which is really bad. So you're educating the licensing board. But another thing you can do off of that is, once you, as parents, as a collective group, you start hitting into the licensing boards on the violations of competence. And the licensing boards are supposed to protect consumers from unethical psychologists. Instead, right now, they're protecting the unethical psychologists from the consumers. And so if you can get that up and exposed a little bit, then you go to your state legislators and start to make noise that the licensing boards are not fulfilling their obligations that they are required to by the state legislature of protecting the consumers, because they have a conflict of interest. The forensic psychologists on the licensing boards who are reviewing these cases have a conflict of interest relative to their review. And so the state legislature should get over here and take a look at whether or not the licensing boards are actually protecting the consumers or protecting the psychologists in the family courts. So that's the next level to take it. Another next level that some of you can take um, accountability is into malpractice lawsuits. Now, that requires that you hire an attorney. Right now, some of the malpractice attorneys may be not familiar with this particular area of law and not work over here. One of the things malpractice attorneys will kind of need is the betrayer, the whistleblower, and that's kind of my role in situations. So if a malpractice lawsuit got up and running, is a potential that I might be reviewing the material and providing an opinion relative to that. I would be considered the betrayer role relative to my professionals. I'm the one who should protect them, and I'm not. I'm exposing their vulnerability and exposing them to injury because it needs to happen. This is child abuse. This is spousal abuse. We have duty to protect obligations that we are failing in. They are failing in. Um, and so those malpractice lawsuits are another thing. I would recommend that if some of you parents have the financial resources and a particularly bad case, a landmark type case, then that's a nice one to pull up. A single successful malpractice lawsuit will change the entire field in the United States immediately. It would be like a Tarasoff range ruling, and people don't know what Tarasoff is. It's a duty to warn ruling that now has psychologists obligated to warn potential victims of violence. It's a landmark case relative to our duty to warn, which didn't actually exist prior to the case. We had duty to protect. It's a little bit, it's an expansion of our duty to protect obligations. We have a duty now to warn the intended victim under certain conditions. That's Tarasoff. A single case out of the family courts regarding their failure in their duty to protect would create a similar kind of situation that would ripple through that we have duty to protect obligations. We have to do a proper risk assessment for possible child abuse. And the truth is, in all cases of severe attachment pathology surrounding divorce, a proper risk assessment for possible child abuse should be conducted. All cases, all of them, because the differential diagnosis for severe attachment pathology is child abuse. So it's either going to be the targeted parent abusing the child, two-person attribution of causality, or the allied parent psychologically abusing the child, a three-person attribution of causality. But it's going to go one way or the other. So in all cases, there should be a proper risk assessment for possible child abuse. And the differential is a shared delusional disorder, so that needs to be specifically assessed for. Is there a shared delusional disorder? There should be a little section in the report saying yes, no, or maybe, but it should be addressed. Child psychological abuse. By which parent? Yes, no, maybe. What's going on with that? Those should be discussions. And so the malpractice lawsuits are around duty to protect obligations. It's helpful if you can get the ethical code violations documented through their licensing board that then roll over. The reason for the ethical malpractice or the reason for the negligent malpractice was the ethical violations, the incompetent in the assessment and diagnosis of delusional thought disorders and attachment pathology. So that's sort of the overall view of the domain of holding mental health professionals accountable. My current practice involves a degree of that, but mostly my goal in reviewing mental health reports is to correct situations that are problematic, where there may have been problematic application of knowledge, and to maybe put things on a proper clinical course for diagnosis and treatment. But in that process, I'm also documenting the ethical violations, professional practice violations, duty to protect obligations relative to the information being reported, um, pursuant to my obligations under Standard 1.05 of the APA Ethics Code when I encounter psychologists where there may have been an ethical violation by the psychologist. I'm discharging that obligation to the involved parent by giving them enough information to move forward with any sort of additional actions that may be warranted in that situation. The To wind up on this whole issue, again, I'm not a happy human that we are here. I don't like hurting people. I wish the forensic psychologist would be more responsible in learning the necessary information and taking it upon themselves to become competent, just basic competence. If you don't know as much as Dr. Childress about the pathology, why not? You must just be lazy because I know it. And I'm not the ceiling, I'm the floor. I'm basic competence. You need to know as much as I do about the pathology. I should not have to educate you in order to have a professional level discussion with you about your patient. Okay. So they have obligations and you have rights. The broader fundamental question. Now, I knew all of this back in 2010-ish, after I got over about 2008, looked at the situation 2010. I know it's a competence issue in the psychologists, and I know why, because the risk management issue and the parental alienation. I know everything is going on, and I developed a path, a solution to it, a strategic family systems intervention, a prescriptive intervention that if you just do it, everything will be solved. And so that's the situation. The solution is unfolding. It's the return to established knowledge. The question, an interesting question, is why is Dr. Childress out here enforcing ethical standards or educating parents about their ethical standards of psychologists so parents can acquire competence? Why am I doing? Where are the licensing boards? They're the ones that are supposed to be establishing competence by enforcing standards, the APA Ethics Code. Where are they? Why are they not enforcing ethical standards of practice relative to psychologists in the family courts? I would argue it's because all referrals about family court cases get shifted over to forensic psychologists to review, and that's an inherent conflict of interest to have forensic psychologists self-reviewing. And that's what we wind up with, is they wind up protecting themselves from a dangerous pathology rather than protecting the targeted parent from the dangerous pathology. And so we need a broad conversation in psychology about how we deal with the family courts issues, and whether forensic psychology has been a success or a failure, and it's been a complete disastrous failure. And how do we get clinical psychology back? We need to get DBT, dialectic behavior therapy, adapted to the courts. Internal family therapy. There's some other family therapy that needs to come over to the family courts and get adapted into this domain over here. Clinical psychology needs to return. There needs to be a higher level of discussion within professional psychology. APA needs to take a look at how it's dealing with the pathology in the family courts. And there needs to be outside and independent review of the field of forensic psychology. They should not be allowed to self-review on this situation. So either the legislatures need to get involved or the APA needs to get involved and have an outside review. I'd recommend a big conference by the APA inviting ethics and assessment and psychometrics and cultural psychology and clinical psychology and child development and attachment people and family systems people and no forensic psychologists, and have them all come over here and get together and talk about how do we solve situation in the family courts. I'd also recommend that the state legislature fund a pilot program for the family courts, give it to a major university, and come up with the diagnostic assessment protocol and the treatment protocol. You can solve it really fast. You can solve it really easy. All we need is accurate diagnosis. We can get that today. If they just start assessing and diagnosing, there's absolutely no reason this solution can't happen tomorrow. If you just apply knowledge. It's a shared persecutory delusion. It's psychological child abuse, protective separation. You fix the child, you restore with the abusive parent. Easy peasy. We need the accurate diagnosis of which parent is abusing the child. With that, I'm going to run off to my Sunday now. So take care and good luck, everybody.